To make the best use of the session, I suggest you do two things. Number one, go through my theory session on legal reasoning. The link to the session is given on the description below. Second, create a free sign-up account on our website and solve the exercise on your own before you go through the video. The process for the free sign-up is also given on the description below. Now that you would have done both the things, let's start the class. Hello students, welcome to another session on practice on CLAT questions, scenario based, which is old pattern questions, but these are case based. Yeah, all right. So let's start with the question. So you may pause it, solve it, and then play the video, because I directly start explaining the question. All right. The Constitution of India guarantees certain fundamental rights to its citizens. Okay. The Constitution also provides that these rights cannot be taken away by state. Cannot be taken away by state. This is the important thing, guys. Even by a law. For violation of this, the person adversely affected by the law may approach the High Court or the Supreme Court for the issuance of an appropriate writ. One of these rights includes the freedom to form association, that implies the right to join an association or not to join such an association. So that's a right which cannot be taken away by state. Okay. Now look at the facts. Owing to some industrial disturbance created by ZATU, one of the several trade unions in AB Chemicals Private Limited, the company issued a circular to all its employees that as far as possible, the employees may disassociate. So it is not allowing its employees to form an association. So now, is the right being violated? Yes. Is the right violated by a state? No. So this principle does not apply. The principle only applies as against a state, not a private limited company. And therefore, the answer would be C. A private company can do that. Yeah. Let's look at number 2. Principle. In criminal law, misappropriation is the intentional illegal use of the property. So basically, 3 things are given to us: misappropriation, embezzlement, and theft. 3 things are given to us. From the facts, we have to figure out which one applies. Okay. Now, misappropriation is the intentional illegal use of the property or funds of another person for one's own use or other unauthorized purpose, particularly by this. So, particular emphasis has been given, but it is also mentioned, or by any other person with a responsibility to care and protect another's assets. So, responsibility is given, right? So, it's a trust which is there. So, I gave something of mine in your care with a responsibility, and then you do this. So that responsibility wala part is important for misappropriation. Let's look at embezzlement. Embezzlement is misappropriation when the funds involved have been lawfully entrusted to the embezzler. So it is entrusted. So in this case also, it is entrusted. All right. On the contrary, which means not like that. It's as compared to that. In contrast, theft is the illegal taking of another person's property or services without that person's permission. So the permission is not given. In both the cases, the first 2 cases, the responsibility has been given, right? So I gave this pen to you. In theft, I did not give the pen to you. You just took it on your own. Okay. Because this says on the contrary. All right. Now, A went for swimming pool at the municipal swimming pool. A handed over all his valuables, including some cash, to X. So he handed it over. The guard on the duty for safe custody as notified by the municipality. So it is lawfully also entrusted. After swimming for an hour, A came out and searched for X. He found another guard on duty, and that guard informed A that X had gone home after completing his shift and did not hand over anything to be given to A. A raised a complaint with the police. X was traced, but he told the police that he sold all the valuables and the entire cash was used for drinking liquor for his own use. What offense, if any, was committed by X? So now in this case, misappropriation is there. He gave valuables under his responsibility. Embezzlement is also there because funds were lawfully trusted. It was notified by the municipality. So दोनों तो है. theft ka you might say that, okay, you gave me something, but I did not take your permission. But here it said on the contrary, as compared to that. So maybe when you do not give it yourself, that would come under theft, maybe. And I'm not using external knowledge of theft, what theft is. I'm just strictly applying to what the principle is given to us. Now let's look at the choice. X is liable for criminal misappropriation and embezzlement. Possible. I'll keep it for a while. X is not guilty of criminal misappropriation. This is not. It was for his personal gain. So B to aram se out ho jayega. If at all X is liable, it is for criminal misappropriation only. See, the language is not that great. It's saying he is not liable. He's more inclined towards गलती नहीं है, और अगर है तो सिर्फ misappropriation की है. So I have to decide between A and C. Now look at D. X is liable for theft as he took. Right. So if I have to compare between misappropriation and theft, misappropriation to pakka hai. This choice is only making him culpable of theft, guilty of theft. So this is out. So now between A and C, I would be inclined more towards A, because he is definitely guilty. C is saying if at all, right? And embezzlement bhi hua hai. There was funds involved. So I'll go with A in this case. Number 3. And these are my facts. When a person falsifies something with the intent to deceive, this is important. The intent to deceive should be there. Another person or entity is forgery and is a criminal act. Changing or adding the signature on a document, deleting it, using or possessing the false writing is also considered forgery. But this is important, guys. This intent to deceive should be there. In the case of writing to fall under a definition, the material included must have been fabricated or altered significantly in order to represent something it is actually not. It should be fabricated or altered significantly to represent something it is actually not, right? So if I'm talking about, let's say, Delhi, if the document was about Delhi and I fabricate it and tell you that it is something to do with Bihar, so then I have altered it significantly. Okay, let's look at the facts here. John was a publisher of ancient books and papers. In one of his books on the world wars, he photographed some letters written by famous historic personalities. A researcher in history noted that in the pictures of some of the letters printed in the book, John had added some words or sentence in his own handwriting to give completeness to the sentences, so that the readers will get a clear picture of the writer's intention. So he's adding something, but he's not fabricating. So something which was missing, which should have been there, शायद उसका fade हो गया, कुछ हो गया, he added those to the picture to give completeness. So he's not fabricating it. Fabricating means झूठा उसको बनाना कुछ, right? So he's not doing that. He's doing that to complete the sentence, and also his intent to deceive is not there. He is not falsifying. Okay. The researcher challenges the originality of those pictures and claims that the book containing the forged letters should be banned. Now, it's not forged letter because it does not come under the definition. Definition of the forged letter is fabricated or altered significantly. He hasn't fabricated it first. There are no false messages there, and neither has he altered it significantly to change the meaning. He's actually doing it to get the clearer meaning what the author wanted of it to be. Okay, author या कौन था, writers, yes. So he's not fabricated. Basically forgery नहीं है. So let's see what are the choices here. Allowing forged publication to be certified, it's not forged, should be banned out. The addition in the letters were made by the publishers in his own handwriting would have made material alteration to the original meaning and hence amounted to forgery. This is not forgery. The additions were made to give clarity, yes, and did not in any way change the contents, yes, and there is no forgery, yes. This is the correct answer. All we have to take the binary decision कि forgery है कि नहीं है, नहीं थी. Let's come to question number 4. In the evidence of law, you may just pause, solve, and then play the video, guys. In the law of evidence, a person missing for long and not heard of for 7 years is presumed to have died. Okay. 7 साल तक no news, you're presumed to be dead as in legal entity. Okay. Now let's look at the facts. A, B, and C are children of F and M. At the age of 20, A went out in search of job and was not contacting the family. All attempts to trace A by the family failed. 8 years after the death of the parents, B and C entered into a partition and took equal share in the property of F and M. 1 year after this, so total 9 years हो गया. Total 9 years. So after 7 years, he was considered dead. 1 year after this, A returned home with his wife and 2 children and claimed his share in the property. Whether A's claim is legally suitable? No, because he is presumed to be dead after 7 years. So there's no existence of his, so no share. Yes. So fourth, the answer is A. Fourth, the answer is A. All right. In case you have any doubt, guys, let's say you think that there's some other choice which makes more sense, you put that in the description. That, sir, why not B? Question number 4, why not B? Or question number 4, why not C? I'll respond to that query of yours. Number 5th. A contract would be invalid and unlawful if the contract is for an immoral or illegal purpose, right? Now, I didn't like the option choices in this question. This is CLAT 2017 question, but yeah, we'll solve with whatever we've been given. All right. So facts. P was a young and helpless widow living on the pavement. R, a neighbor gave her a house registered in her name on the condition that she should allow R to keep his smuggled goods. So that is his consideration, which is okay. Consideration word is not used here. The contract is for illegal purpose, right? So it is invalid. After the registration was done, according to the condition in the contract, our agents went to keep some packets in the house. She refused. R told her the condition under which the house was given to her. She still refused. Is P justified in her action? P is justified, yes, you can say. Contract is invalid. So ideally, the question should ask you whether it is invalid or not, but the question gives us some other choices. R can take back the house by cancelling the transfer deed. See, actually, it is possible because this is an invalid contract. P is right as she did not like smuggled goods to be kept in her house. Possible. P is not justified as she did not have the right to deny. No, this is out. As R was making the contract for illegal activities, P's stand is valid in law, right? So, see, देखा जाए तो A भी ठीक है. But if I were to apply this principle, then the question was, is P justified in an action? If she was justified in an action, she should not have entered into a contract. But between A and D, I would mark D. I'll be more inclined towards D because it is using my principle. As R was making the contract for illegal activities, P stand is valid in law, right? I'm not saying A is completely out, but D, I think, is making better use of the principle. And this was the answer also as per CLAT. Not a great question. Okay. Number 6. Acceptance of a proposal must be absolute and unqualified, which means no counter. So if I'm asking, let's say if I want to sell my black car and you say, okay, I'm willing to buy your black car, but you need to whitewash it. So you've added a condition. So this is acceptance is not absolute and it is not unqualified because you are adding a qualification that you need to whitewash it. So acceptance has to be absolute. In the form I made the offer, you have to accept it in the same way. This is what the principle says. A made a proposal to sell his motorcycle to B for rupees 25,000. B agreed for 24,000. So is the acceptance absolute? No. It would have been absolute if it was for 25,000. So this is not a valid acceptance. A sold his motorcycle to C for 26,000 and next day B sues A for damage. Not worth it because the acceptance was not absolute. B will not get a difference. B can proceed, but he won't get anything against C. B will not get any damages from A. This is the correct answer, right? Let's come to question number 7. Negligence is actionable in law. In simple terms, negligence is the failure to take proper care over something. That's it. So forget about whatever you know about negligence as per the law. Apply only the principle here. It is actionable in law. Simple terms, failure to take proper care over something. Okay, let's look at the facts here. A doctor conducted a hysterectomy sincerely on B, and left a small cotton swab inside the abdomen. So this is contradictory, right? This and this. If he was sincere, this would not have happened. Okay, so don't fall trap for this. Important thing is this. As a consequence of which B developed some medical problems and had to undergo another surgery. Is A liable? Yes. If you're taking proper care, this will not happen. Okay. So 7th, the answer is D. Look at 8th. When a person consented to act to be done by another, he cannot claim any damages resulting from doing that act, provided the act is done in the same for which the consent is given. So if I ask you to do something and you are doing that, what I asked you to do, and in the process some damage happened, right? Yes, in the process some damage happened, then you cannot claim damage if that act was done which I asked you to do. ठीक है, अब पिछले क्वेश्चन को देखे कंफ्यूज मत होना कि सर प्रॉपर केयर लिया कि नहीं लिया, इसमें केयर की बात ही नहीं है. द ओनली थिंग इज if a damage occur in an act being done which I consented कि आप करो. If you came to me and you said कि sir I want to prepare for CLAT, teach me for CLAT, ठीक है, and I teach you for CLAT, but my way of teaching is such that you lose confidence, आपका self esteem खत्म हो गया, confidence टूट गया, तो damage हुआ. You cannot claim for the damage because आप ही ने मुझे CLAT पढ़ाने को बोला था, ठीक है. लेकिन you came for CLAT and I started teaching you IPM BBA के लिए, जो IPM 5-year program है IIM इंदौर का, वो पढ़ाने लग गया. उसमें मैथ्स बहुत हेवी आती है, and because of that you lost confidence and you are not able to do CLAT also. Now you can claim damage because you did not ask me to teach you IPM, you only asked me to teach you for CLAT, ठीक है. यहां देखो क्या होता है. P submitted a written consent to surgeon S for undergoing a surgical operation for removal of appendicitis. तो जब तक ये करेगा तब तक कोई डैमेज नहीं. इसको छोड़ के कुछ और करा तो डैमेज आएगा. The surgeon while doing surgery also removed the gallbladder of A. So for this, the surgeon would be liable. So P can claim damages from S on account of this, not on account of removing appendicitis, because appendicitis बोला था, ये क्यों कर दिया, ठीक है. Okay. Nothing is an offense which is done in the exercise of the right of private defense. So private defense है. Now forget whatever you know about private defense. वो retribution और वो सब जो पता है equal proportionate force, वो सब भूल जाएंगे. Simple लिखा है. If it is private defense, nothing is an offense. Okay. A under the influence of madness attempts to kill B. B to save his life kills A. To save his life kills A. Private defense, right? So no offense. So A के बारे में तो मैं कमेंट नहीं कर सकता. B के बारे में करेंगे. B has committed an offense. No. B has not committed any offense. This is correct. Last question of the day. Okay. Pause, solve, play. Contract is a written or spoken agreement with specific terms between two or more persons or entities in which there is a promise to do something in return for a valuable benefit known as consideration. Such an agreement is intended to be enforceable by law. A unilateral contract. Now, I'm sure this would be what the facts would be dealing with. A unilateral contract is one in which there is a promise to pay or give the other consideration in return for actual performance. So it's a one-way contract, right? So you do something, I'll give you this. This is what it says. There's a promise to pay or give another consideration. Now let's say facts. A toilet soap manufacturing company in India, in order to promote the sale of their product, published an advertisement in all the newspapers on January 1, 2017, that the company has kept a model ignition key of an Audi A3 car. Wow. Sabun use karo or Audi dito. The advertisement also stated that whoever gets the said key before December 31, 2017 from a soap wall, whoever. Okay, this is important and time is important. This will be gifted with the Audi A3 car. Mr. Martin, a foreigner who came into India as a tourist who was staying in a hotel, found a key similar to same car ignition key on 30th September 2017. So before the timeline ho gaya, okay? Mr. Martin brought this matter to the notice of the hotel manager. The manager informed Mr. Martin about the company's advertisement on Jan 2017. Mr. Martin wants to claim the car. Will he succeed? State offer. Whoever, it does not say Indian citizen or something. He says whoever before this. So he's satisfied, fulfills the condition. So that's it. They did not mention you have to use the soap, right? Or you have to buy the soap. If you find in the soap, that's fine. So yes, he will succeed. No, it is Mr. Martin. This is also out. See, first of all, it is yes. No, no, it is gone, right? Mr. Martin obtained the key before the stipulated date, so he's covered by the offer. So yes, this is the correct answer. So yeah, so with this, we come to the end of the class. Guys, again, I repeat, to make the most of these classes, we have put all these questions in the form of a test on our website. It's available for free. The link is given in the description below. Sign up for a free account. Attempt this question on your own first and then come and have a look at the video. In that ways, you'll gain a lot from the exercise. So see you in my next class. Till then, take care. All the best. We at Mentors Capital have curated the best test series for you. We can confidently claim that our test series is best in the market. So go and see it for yourself. Remember, coaching kahin se bhi. Test series from Mentors Capital.